awesome day. It was so beautiful. Just a preview of what's to come. Allow us to have a sensible conversation here tonight that will benefit the people of Demorest. In Jesus' name we pray. Amen.
Amen.
All right. I'll go ahead and call this meeting to order. We need an approval of the agenda.
I'll make that motion.
Second. Okay. All right. Now we're going to move into the discussion of land use and possible amendments to the city's land use code and regulations. Thomas?
Got it. Does everybody have a copy of Cornelia's ordinance? You turn me down.
Thank you.
Everybody got a copy now? The reason that we're looking at Cornelia's is mainly because, and I think I mentioned last time, the mayor suggested that we start with there. For Kansas City, a lot of their, I mean, obviously they've got more developed, especially downtown, but a lot of what they do have in their zoning ordinance is, it seems to, I think, will fit with what we have, what we've got here. Just to kind of orient everybody to the maps, this one right here is our current land use ordinance district map. We don't, as we talked about, those of you that are familiar with how zoning works generally in Georgia, generally speaking, you've got a zoning ordinance that's got various zoning classifications, various residential, commercial, office, maybe some industrial, institutional. Demorest doesn't currently have that. What they've got is low intensity, medium intensity, high intensity, sensitive, and historical. And so, and that's what this is. This map and that map behind, they're the same thing. Those are the city parcel map that's got the boundary of the city, and then it's got the parcels on there. And obviously, we've got a lot of institutional property in Demorest. We've got a lot of, I mean, Piedmont owns a tremendous amount. The hospital is a big chunk. The schools are a big chunk. The city, and what have you. So and so eventually, assuming that the council moves forward with adopting what I have suggested, eventually this is going to be filled in with some color similar to what you may see on Cornelia or Clarksville or any of the other cities around here that have a more traditional zoning. That back there,
1936.
1936. That's an original. I'm not. I don't. Rick may have some ideas of what where that came from. It's been here since I started working. I think it shows the original layout.
It's like a poster
of the city.
That was found the last, when I was on council last. That was found when they were doing some cleaning out.
It was land lots that was sold. They put that up in as posters in train stations.
Is that what they did?
Yeah, the company that founded the city.
I think it was found in this room.
About 2 or 3 years ago, the paper ran a couple articles about the history of Demorest and the family that started it, kind of founded it. He wasn't even from around here. I think it was from New York, wasn't he?
Well, it was a company. They were mostly from the Midwest.
Okay. So what I had proposed to do tonight is I had gone through the Cornelia's ordinance and have identified a few things that I want to just kind of bring to folks' attention, get comments, and I mean this is, as you can see, this is supposed to be a roundtable discussion. So as we go through this, if you have, if you have thoughts, you have suggestions, we are more than open to them. There are things in the Cornelia ordinance that we will not adopt. They have their sign ordinance in their zoning ordinance. We've got a separate standalone sign ordinance, and that's what I typically recommend to cities that they do that. Not be part of zoning, but be separate. They've got some overlays, districts that don't apply to us. Airport overlay, the airport's nowhere near us. And then their downtown overlay. Then we may have some sort of downtown overlay. again, that's gonna be something to discuss. So the ordinance in front of you is I just printed it off Communicode. If you all wanted to look at it electronically, you wanted to be able to search it. If you type in Cornelia Communicode, you will find this ordinance there. You just click on it, open it. It's an open. There's no password required. You don't have to pay anything. So it's you can take a look at it. So a lot of the definitions, we're just gonna walk through it. So the first couple of pages are definitions that they have. There are certain things that we would probably, that I would probably recommend that we change. One major difference between, and I don't know, Cornelia may have changed this, and it's just the new code hasn't been updated. As you go through their ordinance and you look at it, they have what are called conditional uses. And when you look at their use charts, they have permitted uses, they have conditional uses, and then they have X's, which means that particular use is prohibited. It's a chart, and we'll take a look at that chart. If the city of Demorest moves forward with an ordinance like this, we will not have conditional uses. They will be characterized as what are called supplemental land use, or special land use, or special land use permits. Because of the changes in the state law, statutory law, the way that those, if a disappointed landowner is denied a special land use permit, or if they are denied a conditional use, the way that those get reviewed by the courts are very, very different. And because of the nature of those types of uses, we want those characterized as special land uses and not conditional uses. That's a technical legal thing. So wherever, if you're looking through this ordinance, wherever you see conditional use, if we follow this model, those will be special land uses. In fact, last summer, those of you that were watching, we actually amended our land use ordinance to take out and remove all the conditional uses and turn them into special land uses for that very reason. Over on page 10 of 127, Cornelia defines family, and I'm gonna have to take a look. I don't know whether their definition of family is consistent with state law or federal law. I'm gonna take a look at that. Courts have begun to move away from definitions of, or require cities and counties to move away from definitions of family that are just merely folks that are related by blood, marriage, or guardianship. There's all kinds of families now, but that will make a difference how we define family. And oftentimes what cities or counties do, they just simply regulate how many people can live in one house or home at a time, whether they're related or unrelated. That can make a difference when you get to the definition of the uses such as personal care homes, community care homes, those types of things, where you're either taking care of senior adults that may need assistance, they can't live at home anymore, but they're living in a residential environment, or there may be rehab, one that can wind up being a little controversial with substance abuse centers. So those may be things. This ordinance doesn't really address that directly, so that may be something that we really need to do. And then, for instance, there on page 11 of 27, you see the definition of group home. It defines it as a single household or more than two or more unrelated persons, whether or not they are developmentally disabled, under the supervision of a resident manager. And there's a couple of other definitions in this ordinance that deal with similar types of facilities. One of the things, if you go over to page 15 of 127, at the top, there are two definitions: neo-traditional development and new urbanism. This is a type of development, and I'm not sure that this is necessarily something that Demorest is going to be interested in. They may or may not. That is, you see communities like that, where they're narrower streets, the houses are close together. Oftentimes there's no forward-facing garages. The houses and the garages are accessed, and the driveways are behind the front or on the back side of the house, and they're accessed by alleys There's more landscaping. When they say neo-traditional or new urbanism, what they're really talking about is going back to a type of development that is more dense, more walkable, kind of what this definition characterizes it, the way things were developed before there were cars, before everybody had a car. And in some ways, the downtown Demorest area is a little bit like that, especially over there in the area, Blue Ridge, McMillan, Cedar, Common Alley. To the extent that Demorest has anything like what they're talking about with this definition, that area of town would be the most like that. So if the city decided they wanted all their new development, and that's the other thing, when you look around, we don't have, the city doesn't have, you've got Sweetgrass here, it's already zoned and platted. You've got, what's that other one called, Meadows?
Hancock Meadows.
Hancock or Habersham Meadows. That one's already platted. And so, frankly, as I drive around, someone may know different. I'm not sure there's any really big parcels of undeveloped but developable property. Now, there are some farms, but from at least what I understand from general conversation with folks who own those ag areas, at least at this point, aren't interested in turning these subdivisions. Like Mr. Austin's property. I mean, his grandkids may want to do that, but I've never heard him say that he's interested in doing it. So, but that's what, that seems to be kind of the, and as you read through the entirety of Cornelia's ordinance, for and I don't know, I haven't talked to anybody over there, but that in the way they do residential development, that seems to be in some way, they're kind of what they're, at least the way this ordinance is drafted, that would seem to be the way, the thrust of how they want their residential development. When you look at over on the next page, on page 16, and you see the definitions like pedestrian scale development, pedestrian freeway, again, that's in the same kind of genre, same kind of philosophy of development that I was just talking about. If you take a look at bottom of page 17 of 127, they define, one of the things, there's a lot of definitions here, and what you're going to see when you get to the use charts, a lot of the uses that are in those charts are defined here, and that's for a purpose. That the way this ordinance works, if it's not listed, if a use isn't listed in one of the use charts, you can't do it. So in other words, if someone wants to use an example, let's say that tattoo parlor is not listed as a use. Folks don't necessarily have a problem with tattoo parlors, and someone wants to open a tattoo parlor, you'd have to amend the text of your ordinance to include tattoo parlor as a permitted use. That protects the city, because if there are uses that people try to slide in that you don't want, then the city council gets some say about the kind of uses that come into the city. So again, if it's not listed, if it's not specifically permitted, then it's prohibited. They have got, if you take a look at page 22 of 127, and then you put your finger there and you go over to again to Article 15, which is on page 1, at the very end on page 122 of 127. One of the things that they do, that Cornelia has, and it's probably a pretty good idea, is they've got what's called, the definition section is called zone floating, a floating zone. It's a zoning district that doesn't exist yet, but you can ask for, you go to city council and ask them to have your property zoned to it, and it's called planned unit development. Any of you who have done real estate work are familiar with that. A lot of cities and counties have planned unit developments. They might be called multi-use developments. They've got all kinds of acronyms and initials. But essentially what that means is you have to have a site plan. Someone comes in and you got to have a minimum lot size. Cornelius is actually pretty small for a residential PUD, that's what they're called in here. You only need 3 acres. For a commercial PUD, which can be mixed use, you only need 1.5 acres. Maybe it's reversed. It's back there in that in the chart in that park. And that is probably something worth having in Demorest, so that as folks who, develop some of these larger parcels, if the R1 or whatever general zoning classification, that we have, or if you've got somebody, a creative developer that comes in, wants to do something that looks a little more mixed use-ish, wants to do something a little more of that neo-traditional, where you've got a little denser housing, you've got a lot of open space, but you put some ways called neighborhood commercial, like sandwich shop, nail shops, those types of things that people may walk to. That kind of district helps facilitate that, rather than having to zone a particular piece, like say one of these over here, off Double Springs Road, one of the larger parcels. Instead of having to cut it up so you've got part residential, part commercial, part office. I mean, that's a weird place to put office, but just to have a mix of uses, you're not cutting that piece up and putting different zoning classifications on it. You just make it a planned unit development. They do a site plan, and it develops in accordance with that site plan. If you take a look at page 24, 127, that's section 42-13. That's that section I was talking about a minute ago. Uses are prohibited if they are not specifically allowed, and they lay that out in the ordinance. And that's the best way to do it. When you protect from unwanted development, unwanted users coming in. If you look down towards the last half of that page, use occupancy, the section 42-15, they put, and Demorest has a provision like this, although it's a little hard to tease out of our ordinances. But what Cornelia has said, and whether it's the number they use or some other number, it's a good idea to have this, is that the last paragraph of that section says that dwelling units they must have at least 300 square feet of habitable floor area per adult, and there can't be more occupants in a dwelling unit than 1 per 300 feet. So what that prevents is you've got a 1,200 square foot house, and you wind up having 8 or 9 people living there, because that can create all sorts of issues. It can create public safety issues. It can create issues with the neighbors, noise, that kind of thing. So that apply to. I mean, you can have 2 parents. You can have, say, 4 adults there and a bunch of kids, but it's per adult. So it's a good idea to have. So as that's really direct to council as you're thinking about what you want to do in terms of this. Begin thinking about what kind of limit you want there. If you want a copy, y'all have a copy, you want to look at it. Sure. We got an extra copy. One of the things, this really depends in large measure on how many people we have who are willing to participate in this process. What Cornelia has done is they have combined what is called the Zoning Board of Appeals, which is a body that hears appeals from administrative decisions. If a developer doesn't like a decision that Mark makes with regard to a driveway or a setback or height of a building or his interpretation of an ordinance, they can appeal that. If that happens now, it comes to y'all to hear that. We don't have a board of zoning appeals or a board of zoning appeals. There's also a planning commission. Now we do theoretically have a planning commission in Demorest, but what Cornelia has done is they've combined those functions into one body. So sometimes and they call it a board of adjustment. And so sometimes that board of adjustment functions as a planning commission, where they hear rezonings, they hear map amendments, they hear requests to amend the text of the ordinance. Then they make a recommendation to council, and the council can either follow that recommendation or not follow that recommendation. They also act as a board of zoning appeals. They hear the appeals. The other thing that's really important that kind of board hears are variances that are not sought as part of the rezoning. So in other words, let's say, just to use sweetgrass as an example, when they got that zone, let's say that because of the way that, that property lay and the amount of floodplain that was on there and all that kind of thing, that under the zoning ordinance, they would, the minimum lot size, let's say that it was, they couldn't do more than half-acre lots. Well, because of the nature of how they were gonna have to cut the streets in there, they were gonna have to have a certain number of lots that were less than half an acre. They were gonna need them to be, let's say, 15,000 square feet rather than 23,000 square feet. Well, they could, is when they stopped their rezoning, they could ask for a variance to allow up to, let's say, up to 15% of the lots could be less than half an acre. I'm not, again, that's not specific to Sweetgrass, I'm just using that as an example. Those are what are called concurrent variances. And so, because those are so important and so tied to the particular zoning decision, the mayor and council will hear those when they hear the rezoning. If an entity already has the zoning that they want, an owner already has the zoning that they want, or they have already gotten the zoning that they want, they begin the development process, and then decide to find out they need a variance, that's a different process. That is not going to come to the mayor and council if you set it up where you got a board similar to this. That's going to go to, in Cornelia, it's that Board of Adjustments. Depending on how Demorest sets it up, it'd be whatever board you all put in place, or it could still be the council. Why it's important is it makes a big difference if the person is disappointed in the decision they ultimately get, how it gets taken to court. If it's a rezoning or it's a concurrent variance with a rezoning, it's amendment to the text, that is a legislative decision. And the courts are very restricted in how they can review legislative decisions. The concept that we learned about in civics of separation of powers applies at the local level just like it does in Washington. So the courts, and so the way that they review those, all the court can say, if even if a landowner that doesn't like a zoning decision, if they win, the only thing the court can say is that's an unconstitutional zoning. They send it back to the mayor and council to zone it to a constitutional zoning. They basically say, by the zoning decision that you made, by let's say that Sweetgrass had been denied in the state ag, and then the owners took it to court. The court probably would have said that having this piece of property that sits adjacent to a major road, left ag, when they want to build houses there, that's an you've taken the value of that person's property by not letting them rezone to build houses and left it as agricultural. But the court can't say you got to give them residential zoning. All the court can say is you didn't do it right, send it back to council, and the council gets another shot at making it so that you haven't taken their property rights and or developed property.
Thomas, can I say something, guys? Just like we're having trouble putting people on the historical board, these folks that y'all would appoint to this needs to have some type of understanding of real estate, the side of that, to understand what kind of ramifications these developers or property owners asking for. Because they could render a decision that's totally messed up, a misunderstanding. So that's somebody, you already know how hard it is to find somebody to serve on this and to be educated and up to date with continuing ed. So just a point of interest of that.
And one thing that you will sometimes see is the planning commission and the board of commissioners in the county or the mayor and council of the city wind up at odds with one another because planning commissions are making recommendations up or down and the council or commission going in the opposite direction, and that can wind up creating additional conflict. And they have a public hearing just like you all do. One thing that, and this is directed to council and citizens may have some comments on this, that you all may want to think about, especially initially, is not having a board like that. So that all that decision making, at least initially, lies with you all. You still got to give a public hearing. Everybody still gets to come in. You remember when we had the issue down in Arlington with the residential, putting into residential development. People came, we had a lot of public comment. All that's still going to happen, but it only is going to happen in front of the council. On the contrary, but you do run into that issue, and a lot of small towns have this issue, is they don't have enough people who want to serve in these roles, because, I mean, it's work. usually at least one meeting a month. You at least gotta show up, depending on how you set it up. Don't necessarily, if there's no zoning activity, they don't have to stay very long, but they at least have to show up. Or theoretically, you can cancel the meeting, but if as, I think one of the reasons we're doing this, we think there's gonna be a lot of activity, then it winds up being a meeting a month. There's a lot of, you've gotta review the stuff that comes before you, beforehand, so that you can make an informed decision. So that, again, that's something ultimately y'all have to determine. We talked a little bit the last time, those of you that were here, the zoning classifications that.
What page are you on now?
Oh, I'm flipped over to page 28. They've got their residential and their commercial, non-residential, separated by section. Cornelia has, ag, and then they've got 3 different single-family residential districts, R1A, R1B. Someone asked last time what the difference was. If you take a look at, you can see the difference between those, and this is really the only real difference for these, is that for R1, it's 2.4 units per acre. For R1A, it's 3.6 units per acre. And for R1B, it's 4.4 units per acre. Why Cornelia set it up that way, I have no idea. I assume that there was probably some development activity already in the works when this ordinance was passed, and that was it was in order to facilitate that, don't know. Their multifamily district is 12 units to the acre. That frankly seems a little dense to me for Demorest, but as a policy decision, the council's gonna have to make that input from citizens. Then you see the district, the traditional neighborhood development, we talked about that. They allow, one of the reasons that I suggested that perhaps Cornelia was pushing residential development in that direction is if you take a look at page 31, they give a density bonus if you do this kind of development. You get a 25% density bonus. So in other words, if it's 4 units to the acre, then you do, and the general zoning, then you get, you do it as a P&D, meet all the requirements, then you can get 5 units to the acre. And on 20 acres, that's another 20 homes, which is most, I don't know what it used to be for residential developers. A lot of the profit came on the last 10 or 15% of the homes. Is that about right? Yeah. So that's what motivates folks to do those types of developments and give you density bonuses. It really enhances the profitability of the neighborhood. On the next page, page 32, you've actually got to look at the bottom of page 31 to see what the various columns mean. But this is that use chart that I was talking about. And you can see, and I've seen use charts that go for 8 or 9 pages because they listed every possible area. It's a larger jurisdiction, lots of different uses, and they want to make sure that they've covered everything very specifically. And so, but this one's only a page and a half. But you see they've listed everything. If it's not listed here, you can't do it in a residentially zoned piece of property.
What's a good example for something like that for a city that?
Well, some of the more objectionable, I say objectionable, it's traditionally objectionable, let's say, tattoo parlors. I mean, nowadays, 60% of the population is public safety people have tattoos, so it doesn't have to stay stigma. Massage parlors,
No, I mean,
pawn shops.
what cities, like if I wanted to look and compare with a large,
A large one.
yeah,
Lilburn, one of my firm's other cities, has a use chart like this, and it's fairly expensive. I think Brazelton still does it this way. The other thing that you may have if you don't have a use chart, if you go, you remember we looked back and we saw the section where it showed the various residential classifications. Sometimes rather than having a use chart, if you look in that section, they'll have an additional subsection under there that says permitted uses and conditional uses, and then they'll just list them all there rather than having a chart. So you'll find it both ways. So those are two that I can think of kind of off the top of my head that might have a more extensive usage list than this one. After that, you've got the non-residential district. You got various business districts. They do an office professional district. I mean, we'll have an institutional district for all the property we have. We've got some kind of small office along Old 441, but I don't necessarily see Demorest having like an office park or anything like that in the foreseeable future. Maybe someday, but not. So I don't know that necessarily needs to necessarily be a focus. You probably just want to allow kind of small office uses in some of your business districts. Cornelia, because it has a whole lot more state highways, plus the 365 runs right through it. They've got what's called a highway business district. I'm not sure Demorest needs 4 different business districts, and again, that's going to be a policy call for you all to make. They've also got 2 different industrial districts, light and heavy. Again, I'm not sure that we need more than 1 industrial district. Is it fully in the city?
Yes.
It is in the city, so that would wind up being zoned as an industrial use. So that's the kind of thing that you're going to put in an industrial zone in a place like Demorest. While the city of Demorest may not necessarily adopt the overlay districts, Cornelia's overlay districts are on pages 38 and following. You all probably will want to think about some sort of overlay district for the downtown area. City Hall, where the current post office is, farmhouse, where Holden Oversoul is going to be in the old. And what you can do with an overlay district, in addition to having the zoning classifications you've got, you can impose various architectural requirements, signage requirements. You can do some things in those. You can impose requirements in those areas because you want downtown to be different in some way. And the way to do it is if you don't want to put it in the zoning districts, you can have an overlay over certain areas. I'm trying to think of another area where you may want to do an overlay. Why you might do one. Perhaps out by the hospital where the hospital and the cemetery are and that medical office, you might have some sort of medical overlay where you do some special things out there if you're going to encourage kind of more development in that area of medical uses as opposed to what's out there as things out there begin to redevelop. I don't know, just something to think about as you're working through this process. If you flip over to page 46, you see a much more extensive chart with regard to non-residential uses, and you see a lot of P's and C's and X's that I talked about earlier. And then the next section, starting on page 50, you got various special or specific use provisions. So this is where if you want to have 2 of my jurisdictions are now, and if you follow Athens news, you know that Athens just adopted a short-term rental ordinance, that is somewhat controversial and has gotten them sued. That the short-term rentals is kind of the broader category of Airbnb, VRBOs, those kind of things. Those are the websites that oftentimes advertise those things. And so, for instance, what Athens did is they distinguished between what they call home occupation STRs and commercial STRs. Home STRs are those if the person lives there or if they're renting it and they reside there, and that person is renting out part of that residence for short-term rental, that's a home occupation short-term rental. The commercial STRs are when you've got some sort of institutional owner that could be certainly out of the county, they may live in Athens Park, but they own a 5-bedroom house and they're advertising the 5 bedrooms on Airbnb for short-term rental. So I don't know, I know that we have some folks in Demorest that are doing that. I'm not suggesting that we need an short-term rental ordinance now, but you probably do need to deal with accessory apartments, accessory structures on the house. You may want to regulate those, if nothing else, make people get a business license if they're going to do it. Because it is a business and they're making money, and you at least want to know kind of what all that involves. As you flip through the various you see just how the certain things that they address: construction field offices, drive-through facilities. That's probably something you may want to address. You want to limit the number of drive-throughs you have, the windows, if you take a look at page 55 of 127, they've got almost a page-long regulation on home occupations. And if you look down at subsections 10 and 11, they specify what you can do as a home occupation, and then they say what you can't do as a home occupation. So the biggest example of the kind of things you can't do is, as a home occupation, is they don't want you doing medical, they don't want you practicing medicine out of your house, and they don't want you building cabinets and doing auto service. So things that can be loud or noisy or smelly, they don't want you doing home occupation, and things where you're gonna have a lot of in and out patients, they don't want you doing as a lot of traffic, they don't want home occupation. Take a look at page 57, and some of this stuff I'm just pointing out to council to begin to look at and think about whether you want to do something like this. They specifically regulate self-service storage units, and maybe oftentimes we call them warehouses. They basically say it's got to be at least 2 acres and it can't be more than 4 acres. You can't do outdoor storage, so we're not going to allow you to park RVs. We're not going to allow you to do one where people park RVs and boats and those kind of things. And there's different ways to do that. You can allow that, not allow that, but just that is something that you probably do want to specifically address. They've got, if you take a look at page 58 and following, they've got pretty good we've got a good telecommunication too. But again, that's something that you need to regulate. They've got, if you look at page 62, they've got a specific kind of what's called a conservation subdivision. Again, I'm not sure this is something that you are necessarily want to. As I stand here, I can't think what smaller parcels. For a conservation subdivision, that's going to be something that's larger, because a CSO, whether it's dedicated to the city, it's dedicated to a land trust, or it's just set aside and given to the homeowners association, half of the property is set aside for this open space. Usually something passive, trails, a park, those types of things. And so, as you can see, we've got, Demorest has a limited number of parcels where it would make any sense to do anything like that. But it's something that you may want to put in place. So take a look at that, or think about that as you're thinking about how you want to do this. We'll need to address manufactured homes and mobile homes and modular homes. We don't need to talk about the various differences there, but there are differences. You see a zoning ordinance, the next couple pages 66, 67, deal with parking requirements, how many parking spaces you need for various uses. That's something that you'll want to specify in your ordinance that winds up cutting down. You can't wind up cutting down on the amount of impervious surface that you wind up having. It's good to just regulate that and take a look at those provisions for how you can address some of the particularities of dealing with parking. Do you want to allow adjacent property owners to be able to share parking? So in other words, let's say that there was eventually something redevelops there. I'm just using that as an example. Those houses are torn down and somebody builds something there. And we've got all this parking on this site. And assume this was owned by a private entity. would you want to allow a situation where that use and this use could share parking, so that they've got enough parking for their clients, employees, what have you, but they're basically sharing that parking. It's just across a 2-lane street. That's what some of this addresses. So that's something that as you're looking through that's what that means. Start on page 73 for several pages of the sign ordinance. You can ignore all that. We've got it. We spent a good bit of time working on that about a year and a half. One thing that they do have, and I don't know whether you all want to address this or not, is they've got a mural ordinance. If you take a look at page 84, sometimes this is called street art. It is a way, if you have something like this, it is a way to reduce the amount of graffiti that you might experience in your town. Because it, generally speaking, gangs that are wannabes that will tag stuff will not mess with public art unless they just want to get in trouble. Oftentimes they're just trying to mark areas, so they'll pick something that's not going to create a whole lot of problem. If it looks like, one of the things that they figured out in Miami-Dade years ago is if the artwork looks like it was done by children, the gangs will not touch it at all. So oftentimes what they were doing is they were having their parks decorated by kids, or at least the kids participating in that. It was known that was happening, and it really reduced the amount of graffiti that some of the parks in the Miami-Dade area, Broward County, Dade County, that area experience. So that would be the reasons that you may want to think about a mural ordinance and allowing some of that. We've got some buildings where that could be done. Typically, you're going to want a building that's got a stone side or a brick side, that's got no windows or anything like that, where you could actually do a piece of artwork. So as you drive around town, think about that and think about whether you want something like this. I don't know that we see a lot of graffiti now, but as development comes and things happen and Gainesville and Athens move this way, you'll see more of that. Winder does, because it's between Athens and Atlanta.
Does it apply to city-owned buildings or privately?
Absolutely, you could do it on a city-owned building. You'd enter into an agreement with the artist. I've done this in Hiawassee. They've got a couple pieces of that kind of art in Hiawassee, where basically the owner gave the city an easement for that side of the building, and the city paid the artist to draw it, and we maintain it. So the owner of the building gave the city a maintenance easement for that artwork. So,
We have discussed that with Piedmont on the farmhouse and even on Old City Hall. Because the art department now, they don't actually paint it on the brick anymore. It comes into a vinyl that can be stuck onto the building.
So this would be, I'm not necessarily, I'll be honest with you, I didn't review this from line by line, so I don't know exactly how they handle it, but the concept I thought was interesting. So if it's a concept y'all are interested in, we can find some and you can do this. Atlanta tried to do it there was some federal litigation on First Amendment basis about it, and we got some pretty decent direction from the courts about how you could and could not regulate this stuff. If that's something y'all are interested in doing, we can certainly do it.
Thomas, this section specifically,
What page are you on?
86 out of 127. Specifically on number 1, references the Historic Preservation Commission is not in your definitions, and so if y'all go down that road, you're going to want to do that.
We're actually doing it with Historic Preservation.
Awesome.
Again, we ran into the same problem Mark just identified. It's hard to find people. That situation for historic preservation, you know from the state law, there's certain actual requirements for those folks. What they have to have a certain background, but they also have to live in the city, and we may not have the residents of the city who necessarily meet those requirements or even have those interests, so it becomes difficult to put together an HPC if you don't.
Because Rick, we have that issue right now at the corner of Holly and Hazel and Sosby. We don't have a committee. He's made application on the 46th day. He'll get approval by default. I don't have a committee.
So in the original, it's been a hot minute since I've been in here, but the original historic district, that piece of property was included in that one.
It
So
is.
Did that,
It is included because it is right. Yeah, it's right. It's right in here.
did mayor and council at that point in time reference a historic preservation committee?
Or
I don't think we did.
well, it's within that district right there, because that's right here. See this? The historic district is in that color block, and that's where that block is. So he falls in that, and I don't have a way to have a commission to hear his request. He's filed all the necessary items to me. And as Thomas states that on the 46th day, I got up to 45 days to review his with the committee.
There's a safety valve in the Historic Preservation Commission is that if the HPC doesn't act on it within 45 days, it's deemed granted. So
It actually says that in the
it
ordinance.
says it in state law.
Oh,
Yeah.
I didn't think it was in our ordinance.
It's in our ordinance as well, but our ordinance, a lot of our ordinance tracks state law.
So even if it's not a permitted use, which it's a new residential is not permitted in the historic district, as I think, Donnie, you were on that on the council at that point in
I
time,
think
weren't
it
you?
can be just supposed to meet certain criteria. It can't be
Gotcha.
something
I hadn't looked at it in quite some
whack.
time.
And so he has taken pictures of other homes. He has given me his design, things of that sort. You know, we've got that old rock wall on the property. He's got the old cement wall right there along the sidewalk. He's trying to adhere to how he's gonna make this house fit. And so that's what the only thing I could do was take those kind of items from him.
So he got lucky in this one is he's willing to actually comply and work with what's there, not just raise it. On page 90, I'm not, again, part of the wood issue when you take an ordinance, an existing ordinance and begin to work with it. It may contain provisions that aren't necessarily relevant to your jurisdiction yet. Cornelia has got a whole section on infill residential. Infill is when you've got either a space, a couple acres that doesn't have anything on it, and everything's grown up around it and development's moved on. But nothing ever went in there because there was some problem with the lot, either with topo or size or whatever. And so with these infill ordinances, it encourages development on those kinds of lots. The other thing that infill ordinances typically address, and again, you all are going to be more familiar with what you have and what's here. If you've got old properties that are not being used, that are empty or vacant and have been vacant for a while, they may have been on the market, maybe they're not on the market, but no one's going to buy them for what's there now. Someone's going to buy it, raise, and build something else there. Having an infill ordinance may facilitate better development on those kinds of parcels. So whether or not you adopt something like that, you're just going to have to, based on your knowledge and what you know about the community, figure out how many of those parcels are around and whether you think you need to address it or not.
Because council code enforcement will be working on these dilapidated houses, and we have started that. And that's, think about those lots would be your infield also. You've heard about this in Atlanta where they had the McMansions, where they build this humongous house where they tore down this other property there, and it doesn't really fit the character of the property. But it's a $2 million house where a $150,000 house may have been there. So.
And Cornelia specifically addresses that exact issue, the McMansion problem, if you view it as a problem. And they basically say on infill, if you look there on page 890, the second subsection, 42-171.2, it says bulk and scale. if you're gonna do infill development, it's got to fit with the neighborhood. You can't come into a neighborhood that's a street full of traditional
Ranch houses or something.
ranch houses. What's that style with the columns like where Union has? I lived there. I can't remember the name of it.
Colonial,
What's that?
colonial?
Yeah, something like that. And then you can't come in and build a $2 million house. It's got to fit within the neighborhood. That might be a good reason.
Yes.
What's that?
I said unless it's a $2 million colonial.
One thing that you all do want to, on page 92 and 93, they've got commercial buildings. You all probably do want to spend some time thinking about this, thinking about what's in Clarksville, Cornelia, maybe places in Gainesville, things that you like and things that you don't like. So if you all don't want a glass building, even if it's a pretty building in Demorest, this is where you want to say, we don't want glass or reflective materials as exterior construction materials on commercial buildings. You can see there, they've listed the allowable building materials for their commercial area, for their new commercial construction. So that is probably something based on why we're doing this, and what we're doing, you all do want to think about and do want to address in this ordinance. There's all sorts of things that you can do. And if you want to do it in some areas, if you don't care necessarily what it looks like, generally speaking, I mean, the buildings up around the State Farm building, they're nice enough and attractive enough. But if you want something different, if you want something different downtown than you want out there, then you can either do that with an overlay district that has its own commercial building standards for that area, or you can do it generally throughout the city. Again, those are the kind of policy decisions that you all need to be thinking about, and hopefully some of your citizens will be commenting to you about as to what they want and what they think. The rest of the ordinance is basically the procedures for how you change things, how you do amendments, public hearing requirements, what's required when you apply for an amendment, the standards that apply that you have to consider, those types of things. One thing that I do want to point out to you all, and this is something that we haven't actually talked about, and it's an important consideration. If you take a look at page 100 of 127,
If the city goes with this
approach, it's probably going to require either that Mark or Megan become a planning professional. Not necessarily they have to go back to school and get the credentials, but they're going to have to do some training so that they can review an application with kind of planning approach, planning concepts in mind, and write a report. I'm not sure Mark's interested in doing that. I'm not sure Megan's interested in doing that. But one of the things that this kind of approach requires is that if you're going to have an application process, that there's got to be somebody on staff that can take that stuff, look at it, make sure that it's complete, make sure they've done everything that the ordinance requires in terms of an application, and then do some sort of analysis. They don't necessarily have to make a recommendation, at least until recently, and I don't know if it's still the case, in the city of Monroe, the building official, the building inspector was the staff member that did that and basically said it doesn't meet the requirements. But he didn't make a recommendation to council. Planning commission made a recommendation, but the building official did not. In most jurisdictions, that planning official does make a recommendation. They've got some sort of expertise, they've got some sort of background or training, and they review it, they look at the ordinance, they compare it to the comprehensive plan, they look at what's around the property that the zoning is being requested for, and they make a recommendation as to what they think ought to happen. Doesn't mean that you all are bound by that, but it's a process that, if you take a look at Cornelia's ordinance, it's required to be in writing. They can't just look at the paperwork, show up at the meeting, and say, this is what I think. it takes, and these staff reports, from my zoning litigations, I mean, a planner usually they can take 10, 15 hours to do a staff report on an application, and then it's usually reviewed by the director of the department. This is where you've got multiple tiers in the department, but it's gonna take some time. So it's something that if you all move in this direction, you're gonna need to either incent Mark, Megan, or somebody else in the office, fire chief maybe. I mean, he's your building official. I mean, if we were in Monroe, he'd be the one that'd be doing this. He would be the one that would be reviewing it and making recommendations. So that's just because he's not a planning professional. I mean, that's your call, and I mean, frankly, it's up to him too. I mean, I think if chief says, I don't feel qualified to do this, you're probably not gonna make him do it. But I'm just telling you, someone's gonna have to do it.
Because what they'll do also is make additional conditions on approval that they have to do X, Y, Z, or from the landscaping, from additional fencing, additional setbacks. It's pretty detailed, and most apartments who have this, I mean, there's 2 or 3 people and probably in Gainesville that's just their job, is to review when you have that many commercial and residential applications. But because everything, again, let's just say we told them to do 7 things, but they only did 5. Well, we got a problem, because you were told to do 7 things. And that's, again, how this kind of stuff gets policed to be able to handle making sure the developments are done per the plans.
And the other reason you want a staff person doing that is because there's gonna be some negotiation on that. And you as the elected officials and decision makers really ought not be involved in that negotiation process. There's really one major size piece of property in Berkeley Lake that's not developed there along Peachtree Industrial. And we just went through a rezoning request on that. And there were 27 conditions on that proposed rezoning. Some of them were non-controversial. 7 of them were pretty hotly negotiated. And that even involved the lawyers. I mean, they were represented by counsel and I got involved. But before the lawyers got involved, the city manager / planning director had 6 months of back and forth with the developer on that. So it's important to have. If you're gonna go in this direction, and in some regards, y'all probably need to decide that sooner rather than later, because if you're gonna go in this direction, then Mark needs to start to consider how he's gonna staff this, because if we do what we're talking about doing, by November, thing's gonna have to be up and running. And then the last thing, I pointed it out earlier, you've got the very last section of this, after all this procedural stuff, you do have this watershed and wetland regulation. I don't know, do we have a watershed, any watershed property in town, or is any of our properties within 7 miles of the water?
According to what definition of watershed you're using.
Yeah, well, I know it does, but I'm talking about, are we within 7 miles of the water? I don't know. And I'm not expecting you to mention it off the top of your head.
Right, that's done through, yes.
They do it, so we must have something. So we probably are gonna have to put some watershed and wetland regulations in place.
Well, the entirety of the old Demorest Lake is now considered a federal wetland area.
Okay, so yeah, then we're definitely gonna have to. So they Hazel Creek is actually their watershed. If you read through this, you'll see Hazel Creek.
Yeah, that's correct.
So it's and I know Hazel.
And that's when we did the water monitoring, when they go off the river and those kind of things. One of those reports that we did this past year.
And then you'll see I don't know, you'll see how they put together their plan unit development ordinance, and some of them, you'll see that in their residential, they encourage a mix of residential uses and then some accessory uses. And it appears that for the most part, what their mix of uses is directed at kind of brewery, farmland. It sounds like it's really agritourism is really their focus for their land unit development. So I know that's the case. I'm just reading the words on the page. So that's a quick walkthrough of Cornelius ordinance, which is kind of where we're here. In fact, you all change the ordinance. Any questions and comments from either council or from citizens? Other staff?
Good job, Thomas.
Y'all just tell me what direction they wanna go.
It's a lot of information.
And we are meeting again next Monday at 6 o'clock, right here. Again.
If you all want some, if you wanna, and I don't know whether any of you want this, but if you want some kind of general, if you got 6 hours and you wanna listen to lawyers talk about zoning and land use regulation, I can give you some links to some, National Business Institute, that's one of the groups I usually speaking for. I think Georgia CLE also does, some of that. If you're interested, I'll give you the links. I think it'll cost you a couple $100. It seems to me that would be expensible to the city because it's part of your, and you may, depending on what it is, you may be able to get credit for it. So I don't know how it works for you all. But if you feel like you need that kind of information before you make this decision, let me know and I'll give you some links to that stuff.
Council, just the definition on page 2 of agriculture is it contradicts itself in multiple places within this document, just so you'll know. Cultivation or grown of a field or horticultural crop, farm forestry, and raising of livestock, but specifically excluding poultry, swine, sheep, and cattle. I don't know what their definition of livestock is, but that poultry, sheep, cattle,
That's livestock on my.
that's livestock. And then if you look on page 28, when they, you say what?
Emus.
Emus. They don't leave out goats there, so I guess goats are out there. The ag district on page 28 does say it's appropriate for lands needed to be protected for food production and other agricultural uses. So things that were excluded by the definition then seem to be included on page 28, just to clean up, would seem to me.
Yeah, well, I'm glad you pointed out, there's about, as I was reading through this today, there's about a half of issues through here. That, as with most ordinances, and it's true in some of ours, things have been cobbled together over the years. There's some, things that if you look close enough, depending on how you read it, you can see some.
Yeah, and the other one that is worthy of note, since I'm just hanging out in ag just for a while, is page 32 on that use matrix that they have. They've got agriculture, raising of poultry or livestock as a conditional use in Ag 1 rather than a permitted use. And then you turn right around on page 33 at the top, it says horse stables, and that's a permitted use, not a conditional use. So again, just a little bit of cleanup there. It's a little bit contradictory.
Well, it seems clear, I mean, you look at those, it looks like they just want horses.
Evidently, this is not Kentucky.
Rick, what do y'all have on your property? How many acres do you have, et cetera?
Total family land, my mom's and my wife and I's, is 24 acres, 26 acres, something like that, with solid 3.5 in dedicated pasture, the rest of it in woodland area.
And are you I have it down, Meadows, are you divided by a creek from them?
We are. Okay, so there's a creek, we own both sides of the creek.
Okay.
That comes through.
And you would join Mr. Hibbert too?
No, he's further upstream. So
Okay.
our property borders Maxie Skinner's property and he owns just a little bit on the other side of the creek towards Councilman Bennett's and my side.
Right.
The rest of that is phase 2 that was never platted for.
And you back up to both of those, phase 1 and phase 2?
I back up to phase 2, yes.
Okay,
They're directly behind and so that's pretty much where we're situated.
Okay.
So the Skinner property is much like my parents' home place, farm place, larger, a lot of pasture. I don't know if you've been over in that direction lately, council, but
Well, I want to drive down your driveway, but it says don't trespass.
just.
I'm
You come
just
on,
messing with
you
you.
come on to mine. That's to stop the solicitors from coming up the driveway. But come on up and take a look at the old Skinner place. Janelle still lives there. She's still doing well as can be expected, and she probably would love to see somebody come down that way and say hello and look at the old. I mean, he did rabbits and beagles. And he got a mighty quality. I mean, could you hear him at your house?
Oh, yeah,
Yeah.
just like they were at my house.
I-
I'm not even kidding.
Me too. I was down in that hole, and there was, I don't know, early on when we moved back and built, 2 o'clock in the morning, I was standing up in my bedroom
Like whose
and
dogs are on my back porch?
picking up the phone, and my wife goes, what are you doing? I said, I'm gonna call Maxie. I'm up. I'm gonna check and see if he's up. I mean, his dogs were going nuts, and
Well,
she
that's
said,
funny,
hang that
because we
phone up.
blamed you for that this whole time.
Sir?
We blamed you for that.
Well, I got a dog or two, but it ain't that big. Those big
I was
were
like,
nuts.
got Rick's Beagles are back at it.
You know, when he passed and she got rid of those big, he got mighty quiet down in that hole. And at that point in time, I almost missed them, to be honest with you. Not all, but I did. They were fun to watch work.
As you all begin to think about, one last thing, y'all begin to think about the zoning classifications you may want. We've got 5 more copies of this map.
Something like that.
Y'all may want to take one, each one of you, and I don't know how much it would cost us to make copies of these. If citizens want to take it, but you need to buy one of those colored Sharpies or colored pencils, just like you used in 8th grade for the map project. And you need to start coloring in the map what classifications you're going to want on what property. Some are obvious. R1, you probably, and then with institutional, you'll have a commercial corridor along Old 441, a downtown overlay area, things like that. But some of the other classifications that aren't mentioned in here, Pushton used to have one like this. We implemented it when I was city attorney there. They had a residential office classification for their downtown area, because at that point in time, a lot of the old houses in the downtown area of Pushton were not being torn down, they were being converted. Lawyers' offices, real estate offices, insurance offices, a vet, an engineer's office, an architect's office. And so, but we also wanted to let people still live down there. And they even allowed them to live and work. It was almost like a live-work thing as well. And so that's something to think about. But again, y'all are gonna be more familiar than anybody, again, with input from your citizens, as to what folks wanna do, what folks live where, and what may happen with, especially with, and obviously what I'm talking about for that kind of thing is probably gonna be in this area right here, up behind City Hall.
Jerry, the meeting was at 6.
I know.
Not 7.
You're just in time to adjourn.
Yeah, you can adjourn.
Oh, good.
So,
All right, go ahead.
any other questions, or, and then Mark's agenda for next Monday is really to begin to, I mean, y'all need to, over the course of the next week, need to decide if this is the direction you want to head in. And it was some of the things that we talked about. The 2 things that really I talked to them about that I think would be of some interest to you is that if we go in this direction, we really haven't talked about this, Mayor, is that we're gonna need a staff person, a new staff person, or this task is gonna have to fall on Mark, Megan, or.
Can we not use a consultant, like an engineering firm that could review this, her application?
You can, there's firm, I mean, Clark Patterson does that, I mean, there's a number of firms who do that. EMI used to, but they don't have a planner anymore. I don't know if Turnfleet has a planner. You need an engineering firm that's got a planner on
Yep.
staff. Clark Patterson, I know, does. CH2M Hill, I know,
Yep.
does.
Okay, I just didn't want anybody to hear that it had to be a city
Well,
employee.
that's true, and that's a good point. However, it's gonna make your fee structure that much more important, because you wanna make sure
We cover those.
consultants are being covered by the applicants.
Casey, we wake you up.
Sorry, Kevin. All right, any other questions or comments? All right, I need a motion to adjourn.
I'll make the motion. Second.
Done.
Thank
You
you.
did an excellent job running that meeting.
How about a vote? We gotta have a vote.
Y'all just made the motion.
We made the motion. We all,
We just did. The Thomas was asking everybody. Yeah. Guys, thank y'all for coming. Please come back next Monday. And if you need to see one of these